American workers are provided medical expense coverage for injury or illness that happens on the job or off the job. Off the job medical expenses are often paid through group health plans sponsored by employers that are subject to the Employee Retirement Income Security Act and various employee protections that we'll talk about more in a moment. Coverage is also provided through exchanges. On-the-job injury coverage is provided through workers' compensation only in 48 states. Texas and Oklahoma have chosen to provide additional competitive options. Now in Texas, an employer can choose to do nothing for injured workers, which is not a choice that any responsible employer should make. This is often referred to as opt-out, and we do not support that in any respect. Responsible Texas and Oklahoma employers provide injury benefit coverage through a benefit plan that is also subject to those same federal laws and employee protections of ERISA. Today, 1.5 million employees are covered by these injury benefit plans with outstanding benefits that deliver superior results for both employees and employers. We've talked about choice. Now let's talk about innovation. Option injury benefit plans rely upon 4 core principles. The first is communication to employees. Workers' compensation programs provide almost no information to employees on their rights and responsibilities before an injury occurs, oftentimes resulting in attorney involvement. Option injury benefit plans must be fully communicated to employees just like a group health plan, so they understand and appreciate their rights and responsibilities. Claims must be administered in the best interest of the employee, by law, unlike workers' compensation, which focuses more on cost containment. Thirdly, injury benefit plans require more accountability. Employers must pay the injury benefits that are communicated to employees and that may be mandated by state law. Employees are required to immediately report an on-the-job injury, which helps ensure the safety of fellow workers as well as getting more prompt medical care from approved providers and following the provider's direction to get better sooner. Medical providers likewise are held more accountable to focus on what actually happened on the job and to practice evidence-based medicine to restore the employee to their normal life, getting back to their family and to their work sooner. Lastly, option programs create more competition. Competition between workers' compensation and option programs results in lower costs for employers as well as broader coverage when carriers have to actually compete on what benefits they're providing. Workers' compensation and options to workers' compensation both rely upon state and federal laws. State laws specify any benefit mandates, what benefits must be paid to an injured worker. They also ensure that there's financial security available to pay those benefits when needed. Federal laws like the Americans with Disabilities Act, the Family Medical Leave Act, and the Occupational Safety and Health Act apply to both workers' compensation and options to workers' compensation. Options also rely upon the Employee Retirement Income Security Act. ERISA supplies a system of employee protections that includes additional communications on the employee's rights and responsibilities, just like they get in a group health plan or a retirement plan. ERISA also requires that benefit claims be administered in the best interests of the injured worker. And lastly, specifies claim procedures that ensure a full and fair review, including access to state and federal courts.